The Anti-Terrorism Act of 2020, officially designated as Republic Act No. 11479, is a Philippine law which intent is to prevent, prohibit, and penalize terrorism in the Philippines. The law was signed by President Rodrigo Duterte on July 3, 2020, and it repealed the Human Security Act of 2007. Being a special law, general laws like the Revised Penal Code may be applied suppletorily. As stated in the Article 10 of the RPC, offenses which are or in the future may be punishable under special laws are not subject to the provisions of the Revised Penal Code. The Revised Penal Code shall be supplementary to such laws, unless the latter should especially provide the contrary. The first clause should be understood to mean only that the special penal laws are controlling with regard to offenses therein specifically punished. Said clause only restates the elemental rule of statutory construction that special legal provisions prevail over general ones. The main idea and purpose of the article is embodied in the provision that the code shall be supplementary to special laws, unless the latter should specifically provide the contrary. Preparatory acts, as a general rule, are not punishable unless there is a law that defines them as a crime and provides for the corresponding penalty. However, under Section 6 of ATA, preparatory acts which consist in participation in the planning, training, preparation, and facilitation in the commission of terrorism, possessing objects connected with the preparation of the commission of terrorism, or collecting or making documents connected with the preparation of terrorism shall be unlawful and shall suffer the penalty of life imprisonment without benefit of parole and the benefits of RA number 10592. The ATC, or Anti-Terrorism Council, assumes the responsibility for the proper and effective implementation of the policies of the state against terrorism. The Council formulates and adopts comprehensive, adequate, efficient, and effective plans, programs, or measures in order to prevent, counter, suppress, and/or eradicate the commission of terrorism. Under Section 25 of the ATA, the ATC may designate individuals or groups as terrorists upon the finding of probable cause that they are in a conspiracy to commit or are committing acts of terrorism. But what is a probable cause? A probable cause means that the ATC must have reasonable grounds to believe, based at least on affidavits of government witnesses, that the individual or organization is engaged in terrorism. An order tagging an individual or a group as terrorist is also known as order of proscription. It is issued by the Court of Appeals upon determination that the verified application is sufficient in form and substance, and probable cause exists and the issuance of an order of proscription is necessary to prevent the commission of terrorism. The petitioners in the ATA case are questioning the constitutionality of Section 25 of the law, among other provisions, for allowing detention of a suspected terrorism without a judicial warrant up to 14 days from the time of detention. The period of detention may be extended to a maximum period of 10 calendar days if it is established that further detention of the person is necessary to preserve the evidence related to terrorism or complete the investigation. Further detention of the person is necessary to prevent the commission of another terrorism, and the investigation is being conducted properly and without delay. An analyst argues that this provision is essential for counter-terrorism to allow more time for investigators to get valuable information from the terror suspect. A longer detention, according to him, can also provide ample time to facilitate interrogation. It can also incapacitate the suspected terrorist from wreaking havoc. Most importantly, longer preventive detention can lawfully hold suspect when usual criminal charges cannot be filed for some technical considerations. However, does the 1987 Constitution allow detaining a person without charge? Article 125 of the Revised Penal Code provides that detained person must be delivered to the proper judicial authorities, that is, the courts, within the periods prescribed. Otherwise, the public official or employee who is detaining the person on some legal ground could be held liable for the failure to deliver except if grounded on reasonable and allowable delays. It should be noted, however, that the detention period stated under Article 125 of the Revised Penal Code is a statutory and not a constitutional provision. A statutory provision is a provision that is found under the law that created it, while a constitutional provision is one that is found under the Constitution. But it must be noted that all statutory laws are presumed to be constitutional unless declared otherwise by the Supreme Court. As it is a statutory provision, the Congress may amend the detention period as it has done so through Section 29 of the ATA. Upon issuance by the court of a preliminary order of proscription, or in case of designation under Section 25 of ATA, the AMLC or Anti-Money Laundering Council, either upon its own initiative or at the request of the ATC, is hereby authorized to investigate any property or funds that are in any way related to financing of terrorism as defined and penalized under Republic Act No. 10168 or violation of Sections 4, 6, 7, 10, 11, or 12 of ATA. Property or funds of any person or persons in relation to whom there is probable cause to believe that such persons are committing or attempting to or conspiring to commit or participating in or facilitating the financing of the aforementioned sections of this Act. The AMLC has the authority to inquire into bank deposits and investments with any banking or non-bank financial institutions without a court order in case a person or group was designated as a terrorist organization, or upon issuance of a preliminary order of proscription.